Hello everyone. So let's begin with the cyber laws in India. So for cyber related crimes and all those transactions activities are governed by basically the primary act is, as I told you, the IT Act 2000 came into force on 17th October 2000. Main purpose is to provide legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, since we are conducting it on internet, right? And it works on some electronic connection, right? Electricity se work karta hai. So we say electronic data interchange means the data is interchanged or exchanged on an electronic medium, right? Even the communication or commerce or records which are filed, that are all done online. So as I told you, that law will recognize some activities or some transactions which are lawful, which you can very well do, and they are no wrong to be done by the use of internet, because internet was made itself for the beneficial uses that it will entail. But it also recognizes some restrictions, that is in the form of it may describe some transactions as contrary to law, which are prohibited and which you should not perform, because if you are doing that, it will cause some wrongful loss to somebody else, and it will, your act or your conduct will not be responsible, not be respectful to other people who are using the same internet, right? So these are some transactions which are provided the legal recognition, means they are considered to be lawful, whether it is the electronic data interchange, that means you exchange data online, जो PDFs upload, download or exchange करते हो, that is what data interchange. Even the emails that you send, that is what the electronic communication, video call, WhatsApp chatting and all that stuff. And electronic commerce, that is business, Flipkart, Amazon, etc. And electronic records, as I told you, the job applications or the admission applications, the entrance forms, or even those bills, चाहे वो house tax हो, electricity bill हो, these all can be paid online. The payments or such transactions can be done online, Paytm, Google Pay, right? So all these are lawful transactions which can be done. History. In 1996, United Nations Commission on International Trade Law adopted model law on electronic commerce to bring uniformity in law in different countries. So see, as I told you, every law has different set of rules and regulations for governing their own nation, depending upon the situation of people in their country, the civilization, the literacy level, the climate, or the societal conditions which are prevalent over there, right? Something which is a crime in India may not be a crime in other country of the world, right? So the laws differ from country to country. So when this model law on electronic commerce came, it is for the whole world, and whatever it will give, that will also be applicable uniformly to all over the world. That's why it is said that it aimed to provide uniformity in the law of cyberspace to all the countries, so that there will be some guidelines. See, it is a model law, right? So you we did one more model law, and I told you to draw the analogy with your model answer to the questions, right? So it will provide some guidelines or provisions that should be incorporated by the countries in their national laws. The model law aims to enable and facilitate commerce conducted by electronic means by providing countries with a set of universally acceptable rules that are aimed at removing legal obstacles and increasing legal predictability for electronic commerce. So the model law aims to enable and facilitate. Enable means to allow, facilitate means so that easily it may go on. And the main aim is, since the name itself suggests, electronic commerce, so it will deal with how to facilitate and ease the going on of commerce, that is business, which is by electronic communication, by providing countries with some rules and regulations or provisions that would be universally accepted. That means it would be accepted norm or accepted rules and regulations by all the countries who have signed to it, right? Since it is a Commission of United Nations. So whosoever is a part of UN, they have to follow this. And how will the commerce will be facilitated? If whatever are the obstacles, they are removed. Obstacle means badha. Suppose I have to do commerce in MP. I am living in UP right now. I want to do commerce in MP. So, and there is an obstacle that I'm not getting the permission of the MP government. Right? So, my commerce will be facilitated by removing the obstacle of permission. And how will that obstacle be removed? Whatever formalities and procedures or processes or forms that I have to fill up to get the due permission from the concerned government, if I do that, if I fulfill those conditions or those procedures, then I may get the permission, isn't it? So that is by removing the obstacles. And see, these are legal obstacles. To ask for a government's permission to do commerce in its domain, that is something lawful, right? So legal obstacles, and to increase the predictability of commerce, that means we predicting it, that of course commerce is with the aim of doing profits, earning more and more profits is the predictability. And it has to be by lawful means. You cannot do, or the law will never allow you to do something unlawful and earn money out of it. The law will not allow you to enter into a contract wherein you are supposed to kill people, and in exchange of that you will get crores of money from the person who asked you to kill a particular person. ठीक है? This provides for equal treatment. See, these are uniformly or universally, that is in the whole world, these are the accepted provisions by all the countries. That means equal treatment is given to everybody, which is essential for enabling paperless communication. Now when it is done on internet or by electronic means, as I gave you the example of digital signature, you don't have to take out the printout of a particular PDF document and then sign it by your pen physically and then again make a PDF out of it, then again you take printout and that printout with your signature will be the final document. इतना झमेला करने की जरूरत नहीं है. Just that there is a digital signature of yours which is saved on your computer. You can copy paste that onto the documents where your signs are required, right? So that enables an easier way, and that also saves paper, right? If you nowadays in trains also you find out that those travel ticket examiners, TT जिसको बोलते हैं simple language में, they don't carry those huge bulk of sheets of paper with them when they come to check the tickets. They just have a tablet, and in that they have those list of passengers, names, details, whatever are there, and from that they put a check on it, right? So they examine it with the help of tablet. So we are moving towards a paperless communication or paperless world where we will save the papers, right? Because it was the plan for saving trees and environment, right? So we are moving towards a paperless communication. We don't need papers and bills for everything nowadays. Even in malls like PVR or somewhere, the bills are sent directly on the phone number. They don't give you that physical bill, but they do ask if you want that, or otherwise the bill is sent to your mobile number. So that's how we are moving towards the paperless communication and efficient in international trade. So whatever is done internationally, of course, that will promote the international relations between the countries as well. And international trade among all the countries of the world is important because no country is self-sufficient in itself. We depend upon some or the other country for some or the other commodity that we import or we export, because that country also would require something from us and we require something from that. So import and export, that is the trade, goes on and on. India became the 12th country to enable cyber law after it passed IT Act. Scope or extent of IT Act. IT Act extends to the whole of India. Extent means to what portions it extends, its application extends. That means on what all areas it has come into force, or it applies on people living in how much area. So it extends to whole of India. That means throughout India, it applies on everybody. It applies on all Indians living in the whole boundary jurisdiction of the country. Fine. And prior to 2019, everywhere in every act it was written applies to whole of India except the state of J&K, that is Jammu and Kashmir. But after the scrapping of Article 370 of Indian Constitution, J&K is also a part of India, and so that except J&K is now repealed from every act, and that's why now it is said that IT Act extends to whole of India. It applies to any offense or contravention. Contravention means something which runs contrary to law or something which violates law. Contravention is violation. Applies to offense, that is also prohibition, or something runs contrary to law or something unlawful is offense, or contravention committed outside India by any person. Now see, when I say it applies to whole of India, that means the act was committed in India on an Indian citizen, right? And within the jurisdiction of Indian boundaries. I hope when I say Indian boundary, you understand this thing कि ये जो India है ऐसा मैप, so ये इसकी जो बाउंड्री है इंटरनेशनल बाउंड्रीज उस पर लगेगा, सारे स्टेट्स पर इक्वली लगेगा. आई नो आई हैव ड्रॉन वेरी बैडली, सॉरी फॉर दैट, बट जस्ट टू एक्सप्लेन यू, so don't take it personally, sorry. It applies to any offense committed outside India by any person irrespective of his nationality, provided such offense involves a computer system or network located in India. So even if, as I said, the basic feature of internet is anonymity of identity, right? So we don't know where the victim is or where the offender is located. So it applies to whole of India. Other than that, it also applies to offense which is committed outside India by a person, whether he is having the nationality of India or of any other country. Okay, that is the meaning of irrespective of nationality, that no matter he belongs to which nation, जिस भी nation को belong करेगा वहाँ की ही उसकी nationality होगी, जहाँ पर वो पैदा हुआ है उसकी nationality होगी. If you are born in India, your nationality is Indian, right? So irrespective of nationality, wherever the offense is committed outside the borders of India, and the computer system which was used to commit that offense, that is located in India. ठीक है? If a person has committed an offense through the use of computer system located in India, if he has attacked a computer system of India, then he will be governed by the IT Act. But उसको punish करना मुश्किल हो जाएगा, क्योंकि हो सकता है he will take the plea that I am not Indian, so how that law applies on me, and the country itself will not allow such jurisdiction happening. Fine. The courts have recognized cybercrime. Gujarat High Court in Jaideep Vrijlal Depani versus State of Gujarat to mean the offences that are committed against individuals or groups with a criminal motive. Criminal motive means bad intention. You have the unlawful intention that you will cause some wrongful loss to the other person, and if some wrongful loss is caused to him, thereby a wrongful gain or profit is caused to you. So you are tendering to help yourself with some unlawful gains or profits. आप अपना profit करवाने के लिए किसी और को loss में डाल रहे हो. That is the criminal motive. To intentionally harm the reputation of a victim or cause physical, mental harm or loss to victim directly or indirectly using modern telecommunication networks such as internet, chat rooms, emails, notice boards, groups and mobile phones, Bluetooth, SMS, MMS. So there can be many ways of modern communication through internet or mobile phones where the criminal motive can be used to intentionally cause any sort of harm to the person. It provides legal infrastructure for e-commerce, electronic records like online contracts and other activities carried out by electronic means. It deals with electronic governance and cyber crimes. I had told you what all these terms mean. IT Act defines digital signature as authentication means giving consent to, giving authority to, or considering giving consent that whatever document has your signature, it is authorized by you, okay, and you consider that document to be authentic, to be credible. Fine. So, authentication of electronic record means you are giving your sign to it, you are giving your authority to it, and considering that electronic record to be authentic by a subscriber. Subscriber means who is subscribed to it, or user by means of electronic method. So, digital signature is an electronic method only. No, you are creating that signature as a record ऑन कंप्यूटर. सिग्नेचर को एज अ रिकॉर्ड ही तो कंप्यूटर पे इंफॉर्मेशन सेव करना हुआ ना. इंफॉर्मेशन सेव्ड हियर इज योर सिग्नेचर. Section 66A and Shreya Singhal. Shreya Singhal versus Union of India is a landmark case in this act, which dealt with Section 66A of IT Act. 22/12/2008 Information Technology Amendment Bill passed in Lok Sabha. Then after a day it passed in Rajya Sabha. Now you know how bill transforms into an act, right? 2013 9th January, central government issued an advisory. Advisory means it issued a notification or an order giving advice that prohibiting any arrest pursuant to Section 66A of Act unless such an arrest is approved by a senior police officer not below the rank of Inspector General of Police in metropolitan areas or Superintendent of Police in district level. So, it was advised, or the order was issued by the central government, that any arrest under Section 66A will not be done. Prohibiting any arrest means arrest will not be done under this section unless the arrest is approved by such and such officer. ठीक है. So the arrest, if you have to make an arrest under Section 66A of IT Act, then first of all you have to get that approved by the senior police officer. In metropolitan areas, that senior police officer is the Inspector of Police, Inspector General, and for district level it is the Superintendent of Police. Fine. Metropolitan area is a smaller, you can say smaller district. In a way you can say, not the actual meaning it is. 2009 IT Act came into force. PIL filed by Shreya Singhal challenging constitutionality of Section 66A. So whenever constitutionality of a provision or of a law is challenged, that means that we have to examine, rather the court has to examine that this provision or this law runs in accordance with the provisions which are there in the Indian Constitution. As we know, Indian Constitution is the grundnorm, it is the supreme law of the land, and any new legislation which is being framed, that also has to be in accordance to the provisions or principles of the Constitution. And if any law or some of the provisions of that law, they run contrary to the principles of Constitution, then it is said that such part of law or the whole law, if the whole of it runs contrary, it will be declared to be null and void, and we say that this law was unconstitutional. That means it ran opposite to the Constitution, so it is unconstitutional, and anything which is unconstitutional, that is liable to be declared null and void by the court. So that is the meaning of challenging the constitutionality. That means we will check, the court will check whether it stands contrary or in accordance to the constitutional provisions. So Section 66A was challenged by Shreya Singhal. I had also told you a little brief about what PIL is in one of my previous videos. 2015 May, the Supreme Court in Shreya Singhal versus Union of India declared the section to be unconstitutional. Now you know what is unconstitutional as well. So Section 66A hai kya? Section 66A made it a punishable offence for any person to send grossly offensive or menacing information using a computer resource or communication device. So we say that arrests were made under this act, right? If you see this chart now, you know what section 66A, that means it declares an offense, right? It is making a punishable offense. That means it is a sort of criminal provision which is declaring an act to be a offense. Fine. Now see over here, 2012 PIL challenged the constitutionality. Then in 2013 central government issued a prohibitory order that now arrest will not be made under this section because it is an offense. So whosoever has done the arrest, he or she will be arrested for committing that act, right? So यहाँ पर उन्होंने प्रोहिबिशन लगाया कि इस सीनियर ऑफिसर के परमिशन के बिना, अप्रूवल के बिना अरेस्ट नहीं कर सकोगे, ठीक है? एंड अप्रूवल भी ऑफ कोर्स कुछ एग्जामिनेशन, कुछ इंक्वायरी के बाद होगा. ऐसे ही तो उठकर सीनियर ऑफिसर अप्रूवल नहीं देगा. ऑन द फेस ऑफ इट आपने कुछ एविडेंसेस रखे होंगे, जो भी किसी पर्सन के अगेंस्ट आप एलिगेशन लगा रहे हो, कुछ तो आपने इंक्वायरी करी होगी, इन्वेस्टिगेट किया होगा कि हाँ कुछ सब्सटेंस है मेरी बात में, कुछ वेट है मेरी बात में, है ना? कि these are the evidences which show that the case is running or the case is against her or him, whosoever it is, right? So tab approval milega and then arrest can be made. And in 2015 the judgment came which declared that it is unconstitutional. ठीक है? So section 66A declared it to be an offense which shall be punished. Punishable offense means an offense for committing which the person shall be punished. ठीक है? Any person to send grossly offensive or menacing information using computer resource. So if you have sent any information which is grossly offensive, not only offensive but grossly, that means it has attached a more serious gravity to the situation or to the information that has been sent across. You are sending pornographic material, you are sending some morphed images, or suppose a couple had consensual intercourse, but in it the male person who was dating the female, he has taken some photos or he has recorded that whole intercourse, and now he or she, whosoever the case may be, either party can give the threat to the other party that if you not give me this much amount of ransom money, I will leak the video or the photo and I will send it across. So if the money was not given in 1 month as it was given the threat of, he leaks the photo, he sends it across to some third party. So that transmission is a grossly offensive material. What if that third party was the parents of the girl or some relative of the girl, right? So these are all what? Offensive materials. Not only offensive but gravely or grossly offensive. So by adding the term grossly to this expression, it means the degree of seriousness or gravity of the situation is increased. Section 66A was inserted by way of an amendment in 2009. जहाँ पर भी किसी section के बाद capital A लगता है, generally उसका मतलब है कि वो by way of an amendment insert हुआ है. The reason behind amendment was to address new forms of cyber crimes such as publishing sexually explicit materials in electronic form, video voyeurism and breach of confidentiality, leakage of data by intermediary. Intermediary means suppose I am downloading something from the internet. Okay, there may be some internet service provider. Suppose Jio मेरा internet service provider है. I am accessing something on the internet and there is some person who is providing that service to me, है ना? If I am trying to buy an article on Flipkart or some such e-commerce platform, then there is somebody who is selling that also. So that is one party. I am the second party, and the party who is providing such internet services, that flow of data, who is allowing the seller to upload his items on the internet, who is allowing me or facilitating me to view those articles and then choose one of them and purchase it. So there is some internet service provider, no, who is providing the internet services to me and him, right? So he is called intermediary, जो हम दोनों को connect कर रहा है, हम दोनों को intermediate कर रहा है, हमारे बीच में है, ठीक है? So that is intermediary. So whatever information is flowing, that is flowing through him. He also is having access to such information. Why it is said now in WhatsApp that it is end to end encrypted? That means only you two parties who are chatting can see. The other third party or the service provider of WhatsApp chats, they cannot see your messages. It is said, no, that is the meaning of end to end encrypted. Then sexually explicit materials publishing in electronic form, that means, as I told you, the video has been recorded and now they are uploading it on any website, or they are sending it across. Fine. Then video voyeurism is also to expose of the private organs of somebody, the genitals of either male or female. Breach of confidentiality, of course, these are all what? Some things which belong to the private body of the person, but you are breaching his privacy, right? They had to be kept confidential. First of all, whatever the intercourse is happening, it need not to be recorded if it is consensual between the couple. But you are recording it, and not only that, you are uploading it. So that's of course something which had to be kept confidential, but you are breaching that confidentiality. Fine. Or even, I gave you the example earlier, that army documents or army operations, they are not to be leaked, they are to be kept secret, right? Top notch secret hai wo country ka, but you are leaking it, so that is also a breach of confidentiality. Leakage of data, तो मैंने बताया ही है. You are searching something on Google. After some time, the same appears as an advertisement on some other app in which you are working. So that is the leak of data through apps or websites which is happening, and that is also because of the intermediaries. E-commerce frauds like personation, commonly known as phishing. Personation means when somebody else portrays that he is, suppose there is a person A, there is a person B, there is person C. Now, B is doing something or projecting that he's A. ठीक है? He is signing a document projecting himself to be the person A. और जिसको प्रोजेक्ट कर रहा है वो है सी. सी के सामने ऐसे डॉक्यूमेंट साइन करके दे रहा है एज इफ ही इज द पर्सन ए. तो ये वही होगा ना कि ए का नाम लग जाएगा कि उसने साइन करके दिया है. नाउ ही इज लायबल बाय दैट डॉक्यूमेंट, राइट? सो दैट इज the another offense, that you are copying the digital signatures and making misuse of it. That is also that I am stealing the identity of person A to fulfill my ends, my illegal ends, right? So that is identity theft. Phishing is another mode of hacking to steal data. Offensive messages, sending across some offensive messages, right? That can be anything, any sort of flirting, any sort of stalking, or you know what can be offensive if it is said or communicated or expressed to a female. That can be the example. Therefore, the said section 66A imposed punishment and criminalized the sending of offensive messages through a computer or other communication device. So whatever computer, laptop, mobile phones, whatever is your communication device in which you are using an internet, and by making use of it, you are sending across some offensive message or offensive data, offensive video, or whatever such things, they were considered to be an offense. They were considered, criminalizing means these are all were considered the offense, and but due punishment was prescribed for it. However, the act used wide terms which were not defined and hence caused a lot of confusion. Now, something when it is not defined, you can take it to be anything. As I told you in one of the examples, where a particular sentence may lead to different interpretations, right? I was present at the event. Now, somebody can draw the interpretation that she was present the whole day. She was present for 1 hour, she was present for 2 hours. So many interpretations can be drawn, right? So this may cause confusion. See, I am saying, no, this is correct. She was present the whole day if she is saying this. The other person is saying, no, nowhere is mentioned that she was present whole day. She must be present only for 2 hours. इतना कौन रुकेगा? बड़ा बोरिंग सा इवेंट है, इतना कौन रुकेगा? वो भी नहीं रुकी होगी. ठीक है? So there is no certain meaning, no clear thing that can be drawn from your statement. That creates a confusion कि आप बोलना क्या चाह रहे हो. अगर आपने क्लियर बोला होता तो कोई कंफ्यूजन ना होता, राइट? व्हेन वी वर डूइंग विल्स, वैलिड विल, वी डिड this discussion, right? So Over here also, if there is no definition is what? Stating in clear terms that what all will be included under the meaning of a particular expression and what all will not be included in it. Right? This is the purpose of giving a definition. So whichever terms were used, they were not giving any particular definition as per the act. So it was considered to be very broad. जब particular definition नहीं दी गई है तो क्या होता था, that by different interpretations that were done by different people, every person is different, his point of view, his perception and his way of thinking about a particular topic, and how will he act in a particular situation, that will also depend upon the perception of different people, and it will vary from person to person. So the suppose these terms, sending across offensive messages. What are the offensive messages? What would be the criteria for considering a message to be offensive? ऐसा कुछ भी नहीं, कुछ डेफिनेशन नहीं दिया. सो इट वॉज कंसिडर्ड टू हैव अ वेरी वाइड एम्बिट, जिसमें हम कुछ भी डिपेंड अपॉन द जज, अपॉन द पर्सन, कि ये भी ऑफेंसिव है. फॉर सम पर्सन इट मे बी ऑफेंसिव, फॉर द अदर इट मे नॉट बी ऑफेंसिव. सपोज देर इज़ अ वेरी सेंसिटिव फीमेल, उसको छोटी सी छोटी बात भी चुभ जाती है, राइट तो उसके लिए वो मैसेज ऑफेंसिव है. बट अगर किसी और जज के पास गया या किसी लॉयर के पास गया, वो कहेगा क्या गलत है इसमें, इट इज़ नॉट ऑफेंसिव, आई विल नॉट फाइट द केस फॉर यू. सो दैट परसेप्शन वेरीज. ठीक है, एक के लिए ऑफेंसिव की कैटेगरी में आ रहा है, एक के लिए नहीं आ रहा है. लेकिन यहीं अगर क्लियर डेफिनेशन दी होती या कुछ बताया होता कि इस कैटेगरी है, ये क्राइटेरिया है टू डिसाइड, तो कोई कंफ्यूजन नहीं होता. हम सीधे सीधा बोलते हैं हाँ, एज पर वॉट इज रिटन इट इज कमिंग अंडर दिस एम्बिट, सो लेट्स प्रोसीड. Right? So that is causing confusion. As the perception of an individual in defining grossly offensive, menacing information varies from one individual to another. Same what I have given you or told you just now. In 2012, in Shreya Singhal versus Union of India, a batch of writ petitions were filed under Article 32. Batch of means a collection of more than one petitions were filed and they were all compiled. ठीक है, जब एक ही तरह की बहुत सारी पिटिशंस हो कि ये ऑफेंसिव है, ये ऑफेंसिव है, इसको ऑफेंसिव कंसीडर करना चाहिए और ये सारी बातें, अगर आप इसको ऑफेंसिव नहीं कंसीडर कर रहे हो तो अ लॉट ऑफ मोर केसेस विच शुड हैव बीन टेकन अप, दे आर नॉट टेकन अप फॉर द सेम मैटर, दैट यू आर नॉट कंसिडरिंग इट ऑफेंसिव. ठीक है. सो a batch of means many writ petitions were filed under Article 32, raising an important question relating primarily to the fundamental right of free speech and expression under Article 19. Now, this is a very important sort of conflict between the two things, that it is the fundamental right of speech of the person who is sending across the message. Okay? And the person is claiming it is not offensive, it was a very simple message and I have my fundamental right to say anything which I wish for. But it is always said that fundamental rights are not absolute. They come along with certain restrictions, right? So you cannot exercise your fundamental right by violating someone else's fundamental right. When you are sending across an offensive message or video or a sexually exploited video, that ways it cannot be considered, your freedom of speech and expression cannot be kept at a higher level than the breach of privacy which you have committed. And breach of privacy is under the right to life under Article 21. So again, a battle of or a conflict between two fundamental rights. Isn't it? So it's not that only your fundamental right will always be kept at a higher level and it will be given a more preference than the fundamental right of another person. Everybody is equal, right? That's why restrictions are imposed and any right is not given absolutely. So important question raised which was related to Article 19. Immediate cause for concern was Section 66A. The petitioners argued that wordings were too wide and ambiguous, which led to its misuse. Because people used to say that this is not offensive, so this will not come under the ambit of Section 66A, so the person was set free. And once the person is set free, you know what it happens in India basically. अरे हम तो पकड़े नहीं गए, मतलब ये काम गलत नहीं था, and he repeats the act with some other people maybe, right? The petitioners argued that wordings were wide, leading to misuse. Most of the terms had not been defined under the Act. Further, they argued that section restricted the right to free speech and expression under Article 19. Because these cannot be sent across, that means there is a restriction of for such purpose to Article 19. You cannot freely express or you cannot exercise this fundamental right to cause inconvenience or to offend some other person. तो ये एक restriction ही तो हुआ ना आपके right to free speech पे. So Supreme Court in 2005 struck down section 66A. Struck down means it held it or it deleted it and declared it unconstitutional for violating Article 19(1)(a). So this section was considered to be a violative of or a violation of Article 19. Phishing is the fraudulent practice of sending mails purporting to be from reputable companies in order to induce individuals to reveal personal information such as password and credit card numbers. I have given you an example, I suppose, of the emails that your name is drawn in the lucky draw or you have got this amount of bonus, so click on this link to claim. ऐसे आते हैं emails, messages, so whatsoever are. So they appear to be that I am from a very reputable company एंड ये आपको बोनस लगा है. उस कंपनी का नाम देख कर ही लोग इतना प्रभावित हो जाते हैं कि अरे वाह इस कंपनी का है तो ठीक ही होगा, बट दे आर मिस यूजिंग द कंपनीज नेम एज वेल, राइट. सो व्हेन बोनस विल नॉट बी गिवन एंड देयर विल बी अ फ्रॉड कमिटेड ऑन यू, किसका रेपुटेशन लॉस होगा? कंपनी का. एंड इट्स नॉट ओनली द रेपुटेशन लॉस, इट्स ऑलवेज कैरिड ऑन विद द फाइनेंशियल लॉस दैट कम्स विद द हार्म ऑफ रेपुटेशन. फाइन. So I hope you understand why section 66A was considered to be a restriction of speech, and if it restrains the speech and it is not coming within the reasonable restrictions which are given under Article 19 clause 2 of Indian Constitution, then of course if it is not coming in the reasonable restrictions तो वो unreasonable होगा, and something unreasonable that means it is running contrary to the provisions of Constitution. Fundamental right is a part of basic structure which cannot be done away with at any cost, right? So for the same reason 66A was struck down and considered to be unconstitutional. Here this chapter is also over. Thank you so much.